counsel compared to your
Yes,
team.
that's right. I was getting so confused before. Okay, thank you. Welcome to this morning's session of the Kansas Court of Appeals. I'm Karen Arnoldberger, the Chief Judge of the court. I'm here with Judge Catherine Gardner and Judge Leslie Isherwood with me on the panel. We're here to hear the case. And, I think in the last cases, I neglected to say the name of the case and the case number, but we're here in In Re Lentz, case number 118307. So would the parties please state their appearances?
May it please the court, Jonathan Sternberg for the appellant, Diane Wyatt.
May it please the court, Aaron Bailey on behalf of the appellees, Marilyn Lentz and Lanny Kennedy.
Okay, so that is different. Aaron Bailey?
Correct.
And you were not on the briefs, is that right?
On a few of the briefs, I was not.
Okay, and so I just need your Kansas bar number, if you don't mind.
Sure, it's 25110.
Okay, thanks. And it's Aaron, Aaron Bailey.
Correct.
Okay, great. You'll each have 15 minutes to argue. Mr. Sternberg, you can reserve some time in rebuttal if you like. What would you like?
Reserve 3 minutes, Judge.
3 minutes, okay. We are aware of the facts of your case, so if you can get right to the issues, I think it'll make the most efficient use of all of our times. So, Mr. Sternberg, you can begin.
Thank you, Your Honor. May it please the court, again, I'm Jonathan Sternberg and I represent the appellant, Diane Wyatt. Ms. Wyatt, of course, appeals from the final settlement of the estate of her late father, Lanny Lentz, and the appellees are her two sisters, Marilyn Lentz and Lanny Kennedy, and Ms. Lentz is the executrix. Your Honors, the journal entry of final settlement was error and should be reversed and remanded for a new trial. The trial court's findings of value of 4 residential real properties that the estate owns in Topeka lacked substantial evidence in their support, and in any case, are outside the range of any evidence of their value that was before the probate court at all. And I'd like to point the court to a chart that's on page 24 of our brief, which I think is a good guideline to this. It illustrates exactly what the evidence was, citing the record, what the values in the judgment were, and that the two simply do not match. In the final settlement, the burden, of course, is on the petitioner, here Ms. Lentz, the executrix, to prove the contested values of properties. To do that, the law of Kansas has always required that she introduce a certified market appraisal based on comparable properties and do so through a witness competent to testify as to that appraisal's validity. Anything else, including uncertified appraisals, third-party testimony of appraisals, unsupported testimony of oral offers to buy the property, as in all the cases we cite in our opening brief in this court, are not substantial competent evidence. Well, here there are, of course, 4 properties. There's 605 Lindenwood, which had been Mr. Lentz's residence when he was alive. There's 613 Lindenwood, which along with 605 was distributed to the appellees, Ms. Lentz and Ms. Kennedy, as joint tenants in common. And then 517 Polk and 2723 Monroe, which were distributed to Ms. Wyatt. Ms. Lentz did not introduce any certified appraisal into evidence at any point for any of these 4 properties. Instead, all she did was give oral testimony to unproduced appraisals that someone else prepared and she couldn't verify.
Mr. Sternberg, can you hear me okay?
I can.
Great. Let me ask you, before you get into a lot of details, how your client has been harmed. Because when I look at 517 Polk and the Monroe Street property and the chart that you're talking about, what the trial court found was to give her more than the highest appraisal in both cases. Is that correct?
Kind of. So for those 2 properties themselves, but the harm is this. Everyone agreed, based on Ms. Lentz's petition, that we were trying to equalize the division of the estate. The real problem is there wasn't an equal division of the estate, because what you have to do is look at all the properties, all 4 of them, and determine what the values were or should have been. What really happened here, at least from our perspective, and which I think would be addressed well in a new trial, which is what we're asking for. What really happened here is that the 2 properties that the appellees received were grossly undervalued, so they received a windfall. And what my client received was grossly overvalued. So in reality, what we would prove at the new trial is that, well, and frankly, from the only evidence of appraisals of my client's properties, the 2 she received, they were $5,000 record paid, volume 3, pages 10 to 12. This is Ms. Lentz's own testimony. 2723 Monroe was appraised for $5,000. And my client was assigned a value of $17,833. So she was harmed because what happened was an unequal division of the estate. And it was done post hoc and in an unlawful fashion. And as in the Jensen case that we cite in our opening brief from this court in 2004, and the Preeb Properties case from the Supreme Court in 2012, which again, we also cite, what happened, this oral testimony as to unproduced appraisals, someone else prepared, she couldn't verify, are not substantial competent evidence. Ms. Lentz
let me interrupt you again to ask about that. Yes, no one has the appraisals in the record, but isn't there testimony from Ms. Lentz that she was qualified to provide the certified market analysis because of her licensing and certifications?
Well, so a couple of responses to that. First, the actual appraisals themselves have to be in evidence. The Preeb Properties case is about that. In Preeb Properties from the Supreme Court, there was a certified market appraisal that was introduced into evidence through someone who was qualified to do so, the actual copy of it. But the Supreme Court held that that appraisal still was not substantial competent evidence because the values in it weren't comparable. And the point to Preeb Properties is you have to have the actual appraisals in evidence so that we can determine, looking at them, you and me, whether the properties, whether it actually is an appraisal of comparable properties. So the fact that she simply testified as to at least one of them, I believe it wasn't all the properties she said that she had appraised. I think the 2723 Monroe and 517 Polk that my client had received, she testified that someone else had done those appraisals. And in the Jensen case, this court held that when someone else who didn't do the appraisals is testifying about them, that's not substantial competent evidence either there. And that wasn't done in an evidentiary standard, like, they should have objected and it wasn't, it was not a qualified expert, but rather that simply wasn't substantial competent evidence. And so that's, Ms. Lentz also gave unsupported testimony of conversations with others, which is what she based these higher amounts for 517 Polk and 2723 Monroe on, about the possible purchase of two of the properties. This court held in the Brocado case in 2011 that that's not substantial competent evidence of value either. And what I think is most interesting, though, Your Honors, is the appellees don't present any contrary law to any of this. They don't address any of this at any point in their briefing. In fact, in their original brief that they filed in this court, because this case obviously has bounced around from this court up to the Supreme Court and back, and that's what we're doing here. But in their original brief, in response to ours, they don't give any argument at all how any of this was lawful. They don't respond to a single one of these cases. And that's because there simply wasn't substantial competent evidence of these values at all. And this requires reversal and remand for a new hearing. The real problem—
Could you answer what, and just clarify for me, because I didn't understand what happened here. There was some evidence that at some point there was an agreement about the final settlement that was that your client objected to and then withdrew the objection. So could you explain what happened there, or have I gotten that wrong? Or
there was an agreement that the trial court had rejected a while back. So this is a family settlement agreement purportedly signed by all three parties, and my client opposed that. This is record volume 1, pages 67 to 69, and alleged she had alleged it didn't address all the property in the estate. And in November 2015, this is record 1 at 116, the court denied that petition about the agreement. So what happened after that, what led to the hearing below, was in December 2016, Ms. Lentz proposed her own final settlement. And that's record 1 at 223. And that's what my client then filed her objections to and led to the hearing below. Does that help, Your Honor?
Yeah. So what was it? There was some sort of, there was this family agreement, and then there was something about her withdrawing the objections.
Well,
did I get that wrong?
Originally, Ms. Kennedy was the executrix, right, and she was then removed. And right, so that's what happened. And the trial court itself denied her petition that included that agreement.
Okay. All right.
Yeah, so that the agreement doesn't exist for the purposes of the case anymore. That's really what it amounted to.
Let me ask you another question.
Sure.
If we had got to the December 16 hearing and the judge had accepted the numbers that were proposed in the final amended petition, instead of changing them pursuant to his request, actually, that they all be calculated in the same method, would you still have the same complaint that it's inequitable, or are we here just because the numbers changed between the December 22nd hearing and the final journal entry?
Two responses to that. If the numbers had been just as they were proposed originally, and presumably the plaintiff had been, or the appellee had been able to prove those numbers, but if they had been that way, there would have had to be some kind of cash equalization at that point, because the issue was the values had to be equal, and ultimately those values wouldn't have been equal. So, I think that's one big difference. But the other is we aren't here just because the values changed. We're here because they're simply outside any evidence of their range. And that's the real problem here, Your Honor, is that even if we took Ms. Lentz's testimony as to these values and appraisals as true, I mean, just take it as true, which apparently is what my opponent is arguing. They argued that for the very first time in their supplemental brief in the Supreme Court, or the response to our supplemental brief. The problem is even doing that, still, the ultimate findings of the four properties value were outside the range of even that evidence. So take, for example, 605 Lindenwood. The lowest valuation that Ms. Lentz ever made of 605 Lindenwood at the hearing or in her proposal was $55,000. The trial court valued it at $38,787. That's outside the range of any value that she proposed, that anyone proposed. The same thing for 613. The highest valuation of that was $39,000. The trial court valued it above that at $41,000. Same thing with 517 Polk and 2323 Monroe. Again, this is all in her chart. The highest valuation that she gave was 18, but the trial court valued it above that. The highest valuation she gave for 2723 was 17,000. The trial court valued it above that. So even if we take her testimony, even if that somehow was substantial competent evidence, then as in the marriage of Schwein case, which was also about the valuation of property, where the numbers chosen in the end were outside the range, it's still error and requires a new trial. And
Mr. Sternberg,
yes, Your Honor.
I'm sorry to interrupt. I want to make sure that you squarely address the waiver argument, the fact
Sure.
that your clients never asked for an independent appraisal.
Sure, I'm happy to address that. Three responses to that. First, that doesn't change the burden. The burden in the final settlement of an estate, we aren't talking about the original the original appraisement of the estate, the original inventorying of the estate. The final settlement, the burden is always on the proponent, the petitioner of the final settlement, to prove the values. The Supreme Court most recently addressed that in the Hiersted case in 2008. Where they said squarely, citing this court's decision in Engels from 1984, which again, we addressed all of these in our brief too, that it requires substantial competent evidence of value at that time. 59-1202, that's the statute that they pointed to in that letter and that the Supreme Court asked us for supplemental briefing on. And if your honors have it, I'm sure it's in the file for the case. I would, just as my opponent does, encourage the court to look at that supplemental briefing because we address that there in detail. But we know from its placement in the probate code what that's about. So it appears in Article 12 of the probate code, which is titled Inventory and Appraisement. It's not in Article 22, probate procedure, which governs the final settlement of an estate. What 59-1202 is about is when Ms. Kennedy, or Ms. Lentz, the executrix, it has to, under 59-1201, make an inventory of the estate and state the values for it. And those would be the values that control during the life of the estate, such as for the sale of property, like in the Ostrander case we cite in our supplemental brief. It's something that governs during the life of the estate itself. At that point, if anyone else involved in the estate wishes, they can order an independent appraisement. And if not, then during the life of the estate, under 59-1201, the executrix's own valuations govern. But that doesn't apply to final settlement. The final settlement has to actually prove the values left in the estate. There is no case, and they don't cite any, all of their cases are based on statutory language. They say that the language of the statute means that it somehow absolves her of having to introduce evidence of value. The real problem with their argument, though, is exactly what I've already said before, that they seem to be arguing that under this statute, you have to take her values for the estate as true. Even taking her values for the estate as true, the trial court's findings of value are not supported by any evidence at all in the record. And Your Honor, they have never once addressed that in any of the briefing in this case.
Okay, thank you. You're out of time. You'll still have your rebuttal. Mr. Bailey?
Thank you. May it please the court. I think it'd be very helpful just to very briefly outline how an estate works when it's opened. The executor, the personal representative, as we were just talking about, pursuant to 59-1201, lists the property in the estate and lists the values. And then 59-1502 says no independent appraisal of those values will be made unless an interested party requests one. And at that point, the personal representative appoints three appraisers that set the value. End of story. And one of the cases that was cited in our letter and in some of the briefing was In re Wirtz, which directly addressed this issue. 214 Kansas 434. That's a 1974 case. But in that case, kind of the same thing was going on here, where there was an appraisal of some property, but one of the heirs said, "Wait a minute, I want to. I don't think those appraisers should work, and I want to overturn those valuations." And the district court rejected that and said, "No, there's no jurisdiction here for me to do that. All I can do is accept these valuations of the representative or appoint three appraisers to appraise that value." So very importantly, though, some of the cases that were cited by the appellant that goes to an accounting, and there are several cases that address that it needs to be supported by substantial competent evidence, is an accounting. When you close an estate, you're most likely going to have an estate account. Okay, so you're going to close down the bank accounts of the decedent, you're going to pay some bills, and you're going to run that all through an estate account. So when you close an estate or petition to close an estate, you outline an accounting. So you say, so you can show to everybody, here's the money that came in, here's the money that I paid out. So the cases that cited by the appellant talk about, well, substantial competent evidence to prove, show me that funeral bill cost $5,000. Show me that bank account had $20,000 in it. So that makes sense, but there's no case law that talks about appraisement. And when we talk about where statutes are in the probate code, it's very clear here that 5902 addresses appraisement of real estate. So usually at the outset of an estate, you're going to use maybe the county valuations because that's just the easiest way to list your inventory. But when you're dividing property in kind, the executor might need to readdress those valuations. And very importantly here, and I do want to point out at that hearing, and that was Record on Appeal, Volume 3, and I believe it was page 69, the CMA, the use of the CMAs was directly requested by the appellant's counsel. She was the one, it was Cleo Murphy at that time, but her attorney said, we want the CMA valuations used for all the properties. And the court said, I agree, we're going to use a consistent, and I order you to use a consistent valuation method for the journal entry, submit that, and I'll approve it. That's exactly what
that's part of the question. Is it looks like what the court did is not what any CMA value held. It wasn't the same as any of the CMAs that had previously been introduced in evidence.
Right. Well, and I think the difficulty is if you look at that hearing, and I've read that transcript, I was there, and it was very, things were bouncing all over the place as far as what was being testified to and when and what values. I'm pretty sure that I don't think that any of those, and I don't mean to misstate anything and certainly read that, CMA values were brought up for a couple of the properties, but certainly not for all of them. I know they weren't for the Lindenwood properties because there was, I guess, another appraisal, just a normal, appraisal for those two properties, I believe. But I don't think the CMAs were testified to at that point. So when the judge says, I want those CMA values used, and there was no question, no objection or anything to Marilyn Lentz, the then executrix, of her qualifications to do that. But again, that kind of goes back to, does the district court have jurisdiction to entertain these battles? And it doesn't. Subject matter jurisdiction, Hornbook law says, does the court have the power to look at an issue? Is evidence needed for this very issue? And Wirtz, I think, is directly on point that says the district court has no jurisdiction to appraise an estate itself.
Mr. Bailey, let me back up a little bit when you're talking about CMA values, because when I look at the court's journal entry, it says the court directed the use of the CMA valuations, and it refers to exhibits A and B. Exhibit A says CMA copies were provided to counsel on 12/23/2016. That's the date after the hearing. And it lists 3 of the 4 properties. It doesn't seem to list 605 Lindenwood at all. But then Exhibit B, which talks about the approval of the petition for final distribution, lists all the properties, and it lists these 4 properties. It says the source of valuation for each of them. It says CMA. So how did the CMA change between the 22nd, when the hearing was, and the 23rd, when apparently the CMAs were changed?
Well, again, I don't think CMA values were introduced by Ms. Lentz at that hearing for all the properties. I think it was only for maybe 1 or 2. So I don't think we had what we call CMA values. So, like, for example, 517 Polk, the values were testified based on an offer. So those weren't, there was no CMA evidence or testimony or anything that came in from Ms. Lentz. She was saying, well, somebody offered to buy that for 18 grand or something. So she was saying that that's why she put that value on there. So that's where I think that hearing, not CMA values weren't used for all the properties. And I think that was the issue with the appellant, where at the end of that hearing, she requested CMA values be used for everything. So then the other thing, and I do some real estate law, but CMA values are based on what's called a certified market analysis. So you have to look at certain factors that are in the market at that time. You look at comparable sales, and then you use that to get a combined average. So doing a CMA on one day versus another, not saying 24 hours might change that, but again, I don't think CMA values were used for, and I don't have it in my notes, but I know it was not for all of those properties, specifically 518 or 517 Polk and 2723 Monroe, I believe, and not the Lindenwood properties.
Is your position, I mean, it seems to be that you're arguing a couple of things. One is that since these numbers were sort of close to the range, they're good enough to the range that was mentioned in testimony. Or the other approach is that since the values changed between the date of the hearing and the final journal entry, we can trust her because she did CMAs and she was qualified to do them. Are you arguing both of those, either of those?
Well, kind of, it's not trying to be clear, but actually, when you look at the statute 59-1201 and 1202, the executor's valuation controls unless you request an independent appraisal. So I don't care how, I mean, it doesn't matter that it came in on a proposed journal entry. That proposed journal entry with those values came in by the executrix and it was approved by the judge. The judge ordered those CMA values to be used. No objection was ever made within the 14 days under Rule 170, or that is exactly what a motion for reconsideration is for, at that point, you should have objected. So if anything, you're inviting error. The appellant invited error by saying, I want the same test, I want these CMAs used. The court said, I agree, submit the journal entry and then I'll approve it with those valuations. So I guess my argument kind of ties back to that subject matter jurisdiction and that Wirtz case, which says the court can't even, it's not evidence. The court cannot entertain disputes about evaluations. Part of that could be just saving resources. There's probably a lot of policy reasons about why the legislature went that way, but the statutes make it clear that the personal representative is the one who sets those valuations unless we request an independent appraisal. And that was never requested here. In fact, the CMA valuation was what was requested. So it really doesn't, in my opinion, doesn't even matter that the Ms. Lentz was either qualified or not, because it's not evidence. Those are her, she is the executor. Those are her evaluations. That's what she submitted in the proposed journal entry, and that's what the court ended up approving. And again, I think it's very important, not a whisper about valuations until we get to this point. I mean, the motion for reconsideration that was filed was just to reopen this claim. And Judge Berger, I think that was your question about, is that she originally had this purported petition for damages against the first executor. And then at some point, one of her attorneys counseled her and said, hey, we need to drop that or whatever. She withdrew it. And so it was completely withdrawn. So then when we got to that hearing on the motion for reconsideration, we're not even talking about values. That wasn't even, it was all about, I got bad advice from my counsel. I want to go after this, which is, again, I think a serious problem when we get to, okay, well, is substantial competent evidence doesn't need an objection. But if you look at that case law, it'll say findings made by the district court. You do not need an objection to be reviewed for substantial competent evidence. And so, Judge Gardner, I guess what I'm getting at is that it's not a finding. The judge does not make a finding. The judge takes those valuations either through 59-1201, that's what the executor says, or 59-1202, that's what the independent appraisal said. End of story. So I guess it's a jurisdictional issue. Again, invited error. There was no whisper or a mention that these were somehow wrong. And even if we can get to this issue of, well, these findings, are $800 off of what was testified at the hearing. They're within the range. And the other important note, and I know that this is a very convoluted estate, but at the beginning, when that family settlement agreement was reached between the parties, that was modeled after something that the decedent had prepared. Unfortunately, it didn't reach testamentary muster, but the heirs all understood that that's the way their dad wanted to divide everything. That's pretty much where we got to at the end after years of litigation. So we were able to get to the point where the decedent's wishes were honored. For what that's worth, I know that on here, but I do think that is important and worth pointing out.
Thank you. Any questions from the panel for Mr. Bailey? Okay, you have your 3 minutes, Mr. Sternberg.
Thank you, Honor. Let me address the Wirtz case, which he brings up about 59-1202. Wirtz was not about the settlement of an estate. Wirtz was about the sale of property while an estate was still open. Again, 59-1202 applies about the values of property when the estate is open. He just suggested to you, and they have no case law to support this, that on the final settlement, that the executrix, the petitioner, does not have to prove by substantial competent evidence the values. That is simply wrong. In the Park case in 1940, addressing the same statutes, the court squarely said the burden of proof is on the administrator to prove his contention that property in the estate is worth the sum that they advance. When heirs file objections, the executrix has to establish the correctness of his account. That's the Hawk case from this court in 1951. Engels in 1984 adopted all of these cases as well. This has been the law of Kansas for the last century. It's elementary probate procedure that whenever the executor proposes a final settlement, they have to prove by substantial competent evidence. That's Hurstead in 2008. They have to prove by substantial competent evidence the values of the property. 59-1202 has nothing to do with it at all and never has. Wirtz is only about the sale of property to heirs while the estate is alive. Second, this notion about invited error or no objection, this is a finding that the probate court has to make. Hurstead, again, 2008, which they don't address at all, not once. It's a finding the probate court has to make about what values are the values of property in the estate. We had no duty to object. She had the burden. She had the burden of proof. And when someone has the burden of proof to introduce substantial competent evidence, no one has to object that there isn't substantial competent evidence because they're held to their burden. And
Mr. Sternberg, let me interrupt you again and ask that if there is no objection, why isn't a verified petition by the executrix sufficient to be substantial competent evidence?
Well, we did object to her petition. Well, I didn't mean that. If there is no objection to the petition itself, then certainly it's an uncontested case. This was a contested case, and that's why they had a hearing to begin with. So when I say no objection, I meant at the hearing itself or afterward to the journal entry. Now, I'll note that my client didn't sign the journal entry. within the 14-day period. And under 6252, we didn't have to file an objection in order to appeal this issue either. There's a really good case from this court in 2020 called Marriage of Pogge. It's case number 121012, which goes into when are you attacking the sufficiency of evidence for a finding versus the failure to make a finding. We're not attacking the failure to make a finding. There had to be evidence to support these values. And they're trying to say that there was some piece of evidence that was after the hearing. That's elementary, that you can't have evidence after a hearing. And again, we addressed that in our Supreme Court briefs, and they offered no response to that either. As to these CMAs, what my client requested was actual appraisals to be used, not that she just dreams something up out of nowhere. And in fact, 605, 613, and 2723, she testified to appraisals of all of them, which were, again, not what look at our chart on page 24, which again, they don't address, were not what the ultimate findings of value were. And again, we would have to know what those appraisals were. It is a comparative market analysis. We'd have to know whether there are actual comparable properties on there. This was a farce, Your Honors. This is not how the law is supposed to work. She doesn't just get to say it's worth X and then change it to Y the day after the hearing. And that's what happened here. We'd ask the court to reverse and remand for a new trial where this can actually be hashed out using real values.
Thank you very much. Any further questions from the panel? Okay, that'll conclude this matter. Thank you very much. We'll get an opinion out as soon as possible.
Thank you, Your Honors.